This is the initial appellate opening brief, and we are going to look at how they define the split in authority that's going to be so important in this case. Richard Alec Murdaugh is a disgraced former attorney and drug addict. Once a prominent member of the bar, Murdaugh stole millions from his law firm, his clients, and others who trusted him. His law firm confronted him about his thievery on September 3rd, 2021. He resigned from the firm and, after a failed suicide attempt assisted by his drug dealer, entered drug rehabilitation. 3 months earlier, on June 7th, Murdaugh's wife, Maggie Murdaugh, and younger son, Paul Murdaugh, were brutally murdered at the dog kennels of their rural family property in Colton County. Murdaugh was indicted for the murders for related firearms offenses on July 14th, 2022. The jury trial commenced January 23rd, 2023. The Honorable Clifton Newman presided. The state claimed Mr. Murdaugh was confronted at his law firm earlier that day about missing attorney's fees and that he came home and killed his wife and son to distract a bookkeeper investigating those fees and to reduce his financial exposure in a negligent entrustment suit filed over 2 years earlier regarding a boat which Paul allegedly operated while intoxicated, resulting in the horrible death of a young woman. Mr. Murdaugh also admitted all allegations of theft, but vehemently denies murdering his family. After 6 weeks of trial, the case was submitted to a jury at about 3:45 p.m. on March 2nd. The verdict was returned early that evening. Jurors' television interviews indicate the actual deliberations took less than an hour. Mr. Murdaugh timely appealed the verdict. The appeal is separate from this appeal. On August 1st, 2023, the then Colton County Clerk of Court, Becca Boo Hill, published a book, Behind the Doors of Justice, after Mr. Murdaugh's trial. She had been planning to write a book about the trial even before it began. She repeatedly said that a guilty verdict would sell more books and that she needed to sell books because she needed a lake house. The book caused some jurors to come forward and describe Ms. Hill's efforts to obtain her desired guilty verdict through jury tampering at trial. Jurors stated that after the state rested and the defense began its case, Ms. Hill entered the jury rooms often, telling jurors not to let the defense throw you all off or distract you or mislead you, and telling them not to be fooled by Mr. Murdaugh's testimony in his own defense. On September 5th, 2023, Mr. Murdaugh filed a motion to suspend his appeal for leave to file a motion for new trial based on the jury tampering evidence. The court granted the motion. Murdaugh filed his motion for new trial on October 27th. On November 1st, he petitioned the Supreme Court for a writ of prohibition to prohibit Judge Newman from adjudicating the new trial motion based on public statements Judge Newman made after the jury rendered guilty verdicts. On November 15th, the Supreme Court denied the petition as moot because Newman recused himself from hearing the new trial motion. On December 18th, the Chief Justice appointed retired Chief Justice Justice Tol to serve as the circuit judge hearing the motion for new trial. They say that the trial court held a pre-hearing procedure on January 16th to determine who had the burden of proof in this matter and what must be shown to meet that burden of proof and what must be shown to contest what has been shown and proved. At this hearing, the trial court ruled that Murdaugh bears the burden to prove actual prejudice in the verdict rendered. This is the most important part of all of this. This is what they're arguing. This is the part that matters, hands down. Does Murdaugh bear the burden to prove actual prejudice from what Courthouse Becky did? The federal standard says no. The South Carolina standard says yes. And that is what the fight's over. They're saying that the trial court, Judge Tol, erred by ruling that South Carolina courts should disregard binding precedent of the United States Supreme Court that requires it to presume jury tampering is prejudicial to the defendant. The U.S. Supreme Court held unanimously in Reamer, quote, in a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, which means the defense doesn't have to prove it, it's presumed, if not made in the presence of known rules of the court and the instructions and directions of the court made during trial with full knowledge of the parties. The presumption is not conclusive, which seems to mean it can be rebutted, but the burden rests heavily on the government to establish after notice to and hearing of the defendant that such contact with the jurors was harmless to the defendant. So the defense is saying this is what South Carolina should be looking at. And if this is what South Carolina should be looking at, then Murdaugh has met his standard. Then the state must show that it was harmless. After going through the defense's initial appellate brief on the issue of the motion for new trial, they are very clearly arguing that the trial court and Justice Tol got the standard wrong and that the standard applied by South Carolina splits from what the federal standard is to presume that any communication to the jury by state officials, like a clerk of court, like a bailiff, is presumed to be prejudicial, and then it is the state's burden to show that the communication was harmless. The defense is arguing that putting the burden on the defendant to show that it was prejudicial is the wrong standard, and the court should grant a new trial because the court applied the wrong standard, which leaves the South Carolina Supreme Court with a few options. One, they can say, you're right, the standard's wrong, have a new trial. Two, they can say, no, we said in the Green case in 2020 that this was our standard. Let us reaffirm our prior standard from the Green case in 2020. And this is what we mean by that, denied. No new trial, this part is done. Remember, Murdaugh still has an appeal running on other trial issues. This is just the appeal on the motion for new trial. Or the court could say, yes, we agree that the standard needs to be more narrowly defined. We take this opportunity to define our standard better, which I think they may do because they took this out of the hands of the appellate court and took it directly. So I think either way, they're going to take an opportunity to define what their standard is and how their court looks at this, and then say the standard is more clearly this. And with that guidance, we are not granting a new trial, but we are granting a new hearing. Take the standard, because the trial court did not apply this standard, take this standard that we are articulating and take it back down and do another hearing at the lower court and remand it for further discussion at the trial court. And that might be what they choose to do. It kind of sidesteps whether or not he gets a new trial, but it allows them to redefine their standard or more thoroughly define their standard, which if they didn't want the opportunity to redefine their standard or to clarify their standard, they wouldn't have taken this case out of the hands of the appellate court. Normally it would go to the appellate court, and then after the appellate court finally rules, after motions and the potentially year or years long process for appeal, it would go to briefing, and then it would go to oral argument potentially, and then it would get an appellate ruling. Then it would get, that appellate ruling would get appealed to the Supreme Court. The Supreme Court took it out of that procedure and shortcutted it so they could look at it directly. The only reason they're going to do that really is to look at the standard and to articulate it more fully. If they stood behind everything in the Green case or didn't think there was confusion there, they wouldn't have taken this out of the hands of the appellate court. They would have let the appellate court roll through on what the standard is. We'll see what they decide to do with all of that. But what we have next procedurally for the Alec Murdaugh appeal on the motion for new trial is the full defense briefing, because this briefing is not going to count. They're asking for more briefing. It's probably going to be the same briefing we've looked at, modified slightly. Then we're going to get the state opposition, then the defense reply. Then the state Supreme Court is going to decide if this goes for oral argument or if it's decided on the briefing. And then at some point in the future, we will get a ruling from the state Supreme Court and see what happens there. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.